In this video, we'll be talking about pretrial conference in the context of a criminal defense case. Now, anytime you're going to have a trial, whether it's a jury trial or a bench trial, you're going to have a pretrial conference or a final pretrial conference right before trial. This usually happens just a couple of days before the trial is to begin. And what happens at the pretrial conference is a lot of different things. First, if there are some pending motions in limine, a judge will usually rule on those to decide what's going to come in as evidence, what's not going to come in as evidence, and how you're going to address concerns that either the state or that a criminal defense lawyer has about how evidence is going to be presented in the case. They'll also talk about the timing of the case, how long the case is to be expected, how long they anticipate that voir dire will take, and kind of lay out a roadmap so that both the state and the criminal defense lawyer and you are all on the same page as how this trial is going to go. Now, obviously, they can't anticipate every single thing that will happen at trial, and the judge will have to deal with problems that may arise. But this time, this pretrial conference is basically there to get out every single thing, iron out every single problem that either side can anticipate. This is also done to save time. And the pretrial conference is going to limit a lot of the back and forth between the lawyers on the day of trial, which will make the trial go a lot quicker. Depending on the judge may go ahead and pull jurors or establish the jury pool. This would be a time when you would get juror questionnaires, things like that. And anything that we can do to limit the amount of time that a trial takes will be handled at a pretrial conference. One of the final things that happens at a pretrial conference is because at this stage, your lawyer and the state's lawyer are usually ready for trial. They've looked at all the evidence. They've looked at all their own discovery, the other side's discovery in most cases. They're going to have a very good sense of what is going to happen in the case and where their weaknesses are in the case. So this is a good time if there is any middle ground to be had on a plea or some sort of thing that can be done in exchange for a dismissal, then this is a very good time to flush out any opportunities. If you have any other questions about a pretrial conference in the criminal defense case, if you have any other questions about the criminal defense process or any element of the criminal defense process, please view our website, rothdavies.com.